In this lesson, we're continuing our discussion of witnesses and testimonial evidence. Specifically, we want to focus on testimonial privileges under the common law and rules 501 through 502 of the Federal Rules of Evidence. But before we get into it, as an overview, what is testimonial privilege? What am I talking about here? Well, privilege is really easy, right? And most of us probably have some idea of what privilege is, but just to refresh, right? If you hold a testimonial privilege, you're sometimes referred to as the privilege holder. That is going to give you the option to exclude certain types of communications and statements from being brought into court. And this is usually based on your relationship with another party, right? And we have some of the more important testimonial privileges here on the board. We have confidential marital communications and spousal immunity, which deals with communications between spouses. We have physician-patient privilege, which deals with communications between a physician and a patient. And we have attorney-client privilege, which deals with communications between an attorney and a client. And in all of these situations, right, we're saying based on this relationship, certain communications that are confidentially made between the parties should be excluded from coming into court if the privilege holder wishes to have those statements excluded, right? So our core concepts, though, here with testimonial privilege, also notably too when we're thinking about spousal immunity and maybe even the Fifth Amendment self-incrimination clause, right? In some situations, not only can the witness exclude, or the privilege holder exclude certain types of statements, but they may even be able to refuse to testify altogether. We know this very well with criminal defendants. The criminal defendant has the option to testify or not testify, right? That's a type of testimonial privilege. She can refuse to testify at her own trial. And we'll see this is similar too, okay? So the privilege holder gets a lot of really cool benefits, right? In other words, right? Basically, they can either exclude certain statements that were confidentially made outside of court from coming into court, and in some situations, we'll see they can even refuse to testify. They cannot be compelled to testify at trial, okay? So up here on the board, though, we have our core concepts, and there's a dozen or more different types of privileges you can really look at, because ultimately this is one of those areas where we kind of have to go away from the Federal Rules of Evidence. Because we take a look at Rule 501 of the Federal Rules of Evidence. 501 tells us, hey, you know what? We're actually going to take a pass on testimonial privilege. So long as the federal rules don't say otherwise, you can go with common law principles here. That's really what 501 is saying. The 501 drafters of the Federal Rules of Evidence are basically saying, hey, look, we think the common law is developed enough in this area of testimonial privilege. Apply common law principles unless a federal statute says otherwise, or you have a diversity claim in federal court where we can apply some sort of state law. But otherwise, let's apply common law principles. That's really what 501 is saying. We'll see some limitations with 502. But for that reason, right, we can go to the case law. We'll see all kinds of different privileges and rules. So what we're going to focus on in this video is the big ones, right? These are the commonly tested in terms of an evidence fact pattern. These are the ones you really want to be aware of. And if you understand these and these core concepts, if you did see another type of privilege tested, I still think you would be in good shape. But we'll put more information about other privileges not on the board below this video. But here, let's just get a grasp for how privilege works, what it looks like, and we can start with these core concepts. Because if you know these core concepts, these four concepts I have on the board, you're going to be in excellent shape on an evidence essay or an evidence fact pattern regarding privilege, okay? So the first thing we want to do when we're approaching an evidence fact pattern and we see a privilege issue, we want to identify, number one, who is the privilege holder? Remember, the privilege holder, that person is the only person who can assert the privilege, and that's the only person who can ultimately waive that privilege. And it's usually got to be one or the other, right? As that trial goes on, either the privilege holder is going to assert that privilege, or they're going to waive that privilege, right? So number one, we want to identify who has the privilege? And most of the time, this is really easy, right? If it's a professional relationship like physician-patient or attorney-client, it's the patient, it's the client, it's the person who's receiving the services from the professional is going to be the privilege holder. So this is usually really easy. The only nuance to this really is in spousal relationships, right? Where we'll have some things we want to consider as to who holds the privilege, but we'll get there in a minute. Our second core concept that we really want to think about is confidentiality, right? And this is critical. Confidentiality is at the heart of privilege, right? This is why we have all of these different forms of testimonial privilege. If a statement is not made in confidence, right, you get on a microphone, you get on your megaphone and go announce something to a room of people, well, that statement is not going to be privileged, right? That's not confidential, right? The whole point of testimonial privilege is rooted in this idea of confidentiality. So we're only really looking at statements that are made between parties in confidence, right? So this is a huge gateway kind of issue you can ask. No matter what privilege you're applying, you want to think about whether the statement is made confidentially or not so, right? Number 3, we have this idea of scope. We always want to keep the scope of the relationship in mind and the scope of the statement in mind. You know, for instance, generally, statements that are made outside the scope of the relationship are not going to be privileged, right? If you go to a lawyer or your physician, it doesn't matter who, say you're a patient, you're going to go seek medical diagnosis or treatment from a physician, you get to the physician's office and the physician asks you, oh, how did your weekend go? And you're like, oh, it was great, except for, you know, I burglarized this home in my spare time, right? You confess to some crime to this physician. Well, that's outside the scope of that physician-patient relationship. That has nothing to do with medical diagnosis or treatment. That statement's not going to be privileged, even though it might have been made confidentially, right? It doesn't matter. Even though that might be a confidential communication you made to this physician, it's completely outside of the scope of the relationship. So it's not going to be protected. It's not going to be privileged, okay? So that's always another big one and a commonly tested aspect of a privilege analysis we want to look out for. And finally, we have waiver, right? Ultimately, even if a statement is made in confidence within the scope of the relationship, it's made in furtherance of this relationship, right? And it's made in confidence, a privilege holder can still waive that privilege. And the first and biggest way that you want to look out for waiver on an evidence fact pattern is if the privilege holder volunteers that privileged information, that confidential information, to third parties not involved in the relationship, right? So if you go to a physician, you go to a doctor, you seek medical treatment, and you have all these confidential communications between you and the doctor, right? Well, that's all covered, right? It's confidential communications, it's within the scope of the relationship, so you have privileged communication. You as the patient are the holder of that privilege. Well, if you go out there into the world and start disclosing, you start volunteering all this privileged communication to third parties, right, you're going to waive that privilege. You're not going to be able then to exclude those statements from coming into court based on privilege, right? Because you're volunteering this confidential communication to third parties, right? And so that's the big one we want to always be looking out for with waiver. Now, notably, and I can just say this right now, usually anytime a third party hears a confidential communication, it's generally going to waive your privilege, unless, right, and there's a few exceptions. If there's secretaries in the room or a nurse in the room who's involved in the relationship or the transmission of the information back and forth, that does not waive the privilege, right? So in that example, if you had a nurse in the room, right, that doesn't waive the privilege. Also, if there's like an eavesdropper, right? This is a common fact pattern. Someone's got a cup on the wall and they're trying to hear something, right? As long as you intended it to be confidential, that's not going to waive that communication. So just because someone's listening in unbeknownst to the parties, right, that won't be waiver either in that case. But for the most part, otherwise, if third parties are hearing this information, you're just at a party talking loudly, or you're in a room where there's other third parties that could maybe hear you, right? That's waiver. Eavesdroppers, not waiver. But if it is obvious that there's other people around who might be hearing you and you're talking loudly, right, that's going to constitute waiver, especially if those third parties are hearing the communication, right? So that's the big type of waiver, and the one we always want to have our eye out for on an evidence fact pattern, right? When someone's volunteering information to third parties, even if it's confidential information to third parties outside the scope of the relationship. The others that are notable would be you can contractually agree to waive privilege. You could just sign a contract waiving your privilege in certain situations. Also, we could have the idea where if you fail to waive, so basically, right, if you fail to assert your privilege, it's basically going to constitute a waiver. Remember, the privilege holder, if he wants to keep a communication out of court, he has to actually assert that privilege. So failing to claim or assert your privilege will ultimately constitute a waiver. So just want to be on the lookout for that too. It does have to be asserted by the privilege holder. But again, the main waiver we're looking for is third parties, volunteering confidential communications to third parties, okay? But that's our 4 core concepts. Just again, real quickly, number 1, we want to identify who holds the privilege. That's the party, and that's the only party who can assert the privilege, and that's the only party who can waive the privilege. Now, of course, you could have an agent, right? If you want your attorney to assert that privilege on your behalf, that's fine, right? But you, the privilege holder, are ultimately in control of that decision as to whether or not to assert a privilege, right? Confidentiality, remember, the core, the entire purpose of privilege is to protect confidential statements. If you make a statement out on a microphone, a loudspeaker, right, that's not protected by privilege. Remember this, we're only protecting statements that are within the scope or in furtherance of the relationship. And remember, even if it's a confidential statement made within the scope of the relationship, you can always waive it by volunteering that information to third parties, right? If we understand these 4 core concepts, all we got to do is apply them to some different relationships and situations, and we'll see with some examples how these core concepts play out. But you're going to see it's very similar, right? No matter what the privilege is, it looks the same if we know these 4 core concepts. Number 1, we can start with confidential marital communications. This is communications made confidentially between spouses, right? So, communication between spouses is privileged if the communications were, number 1, intended to be confidential, and number 2, made during the course of the marriage. Okay, so who holds the privilege, right? That's always our first question. With confidential marital communications, who holds the privilege? Well, like we said, spousal relationships are a little bit unique because both parties actually hold the privilege. Both spouses can assert that privilege or waive that privilege to have their communications come in or not come into court, right? Both spouses hold the privilege for confidential marital communications. Very important that we recognize this because we're going to see a small difference here with spousal immunity. But question number 1, confidential marital communications, who holds it? Both spouses hold it. So either spouse can assert this privilege, right? And what do we do to make sure that they actually can assert the privilege, right? Well, these 2 elements have to be met: confidentiality and scope. Communication between spouses is privileged if the communications were, number 1, intended to be confidential. Again, we already talked about this. If the statements were made while the spouses were in a room by themselves and they don't know anyone's listening to them and they think that it's being done in confidence, right? We all know what confidentiality looks like. Now, if the spouses are just at some party and they're talking loudly to each other and their neighbors or whoever else is there can hear their communications, that's not confidential, okay? So as long though, the classic would be pillow talk. The spouses are at bed at night, quietly talking to each other. That would be kind of the epitome of confidential communications between spouses, right? So as long as the spouses though intended for that, or the privilege holder, whichever one's trying to assert it, as long as it was intended to be confidential and made during the course of the marriage. This is the key here, right? We're thinking about the scope of the privilege, right? Well, with marriage, it's actually just a time definition, right? In some of these other cases, we'll see it has to be within the scope of the relationship. But in a marriage, basically, if it's intended to be confidential, we're going to say it's within the scope of the marriage relationship, right? But the scope question for confidential marital communications is going to be whether the statement was made during the course of the marriage. So if it's the night before the wedding and the spouses are in confidence talking to each other, are those statements covered by the confidential marital communications privilege? No, right? The night before the wedding doesn't work. What about the day after the divorce? No, doesn't work, right? Only statements made during the course of the marriage are privileged, okay? So if the statement was made before the marriage or after the marriage, it's not privileged. Now, notably, if the litigation, if the action is occurring after the marriage, that's fine. If we have a divorce and we have litigation 5 years later and the statement was made during the course of the marriage, that privilege holder can still assert that privilege even though the marriage has since dissolved, right? As long as the statement itself was made during the course of the marriage, it is privileged, right? If it's confidential and made during the course of the marriage, it's privileged. Of course, as always, we know there's always waiver, right? So even though both of these could be satisfied, if the privilege holder discloses that confidential communication to a third party, you will have waiver, okay? So that's confidential marital communications, pretty straightforward. The next one we have is spousal immunity. Now, spousal immunity is a little bit different from some of our other privileges in the sense that spousal immunity. Thank you so much for watching this video preview of our Legal Education Accelerator Program, or LEAP for short. If you would like to see the conclusion of this video and gain full access to our entire 1L and 2L video library, integrated outlines, streamable audio versions, additional practice exams with explanations, and much more, we invite you to head over to our website and join the thousands of law students who have already enrolled. To get started with your no-risk free trial today, simply click the link in the description box below or visit www.studicata.com/leap.
Hi everyone, my name is Serena and I'm currently a law student at South Texas College of Law, Houston.
Hi everybody, my name is Shiva and I'm currently a law student at Southwestern.
Hi everyone, my name is Michelle and I am a first year student at South Texas College of Law, Houston. I used the Studicata study video series last semester to help me prepare mostly for contracts, and I actually made an A+ in contracts last semester, which I greatly dedicate to the Studicata videos.
By using Studicata to help me prepare for my final exam, I was able to score the highest grade out of my class on the final and even have my essay distributed as the model answer. Not to mention I had done quite poorly on the midterm and was struggling throughout the whole course of the semester, understanding the material and keeping up with lectures.
Because of the Studicata video lectures, I was able to go into my exams with a feeling of confidence. I didn't have to worry about what the rules of law were or how I was going to organize my answer to an essay question.
I would absolutely recommend the Studicata series and their online course materials to anyone. I think that they are not like professor lectures that you might find online or other outside study materials that you may encounter. I think that the Studicata videos really focus on not only ensuring that you understand the material that you're going to encounter on your final, but they also help you to understand kind of the best method for test taking, and they really break down how to approach each problem and the best ways to tackle certain methods on testing, and I think that's really important, and I think it's really special. I don't see that anywhere else in any of the other online resources that I've found. So I would certainly recommend Studicata to anyone who is studying in law school right now. Good luck on your studying, and you're going to do great.
I would definitely recommend Studicata to anybody watching this video. Give it a chance. I'm positive that you will love it, that you will get a lot out of it, and that you will be happy that you gave it a chance. I definitely am. I know I will be using Studicata in the future.
And I cannot thank Studicata enough for getting me through my first semester of law school. I will definitely continue to watch the Studicata video lectures throughout my law school career, and I highly recommend that any future or current law student do the same.